So I get the chance today to introduce my colleague, Professor Carol Peterson. She is a professor of law and the graduate chair at the Matsunaga Institute for Peace here at the University of Hawaii, Manoa. Carol is a graduate of the University of Chicago and then attended Harvard Law School. And moving on in her career after, I think, some law practice in New York, I'll see if the head nods up and down, Carol made her way eventually through Hawaii to teach at Hong Kong University from 1989 to 2006 before joining our faculty here. Carol is a prolific scholar and a commentator, and I will just mention that you can find her work in many publications. You can look on SSRN, which for public access available materials, and also our website, the law school's website, provides links not only to her publications, but to other video presentations that she's given. I want to acknowledge thanks to Zoom for making this possible and bringing people in from all around the world, which is pretty exciting, including some VIPs who are joining us. And I also want to give a shout out to my colleague, Allison Connor, who is joining us today as well. We're delighted to have Allison here. Finally, I want to thank the participation and cooperation of the Matsunaga Institute, the Center for Chinese Studies, and the East-West Center. With that, we'll hand this over to Carol. We may have a few comments after from one of our guests, and then open it up for questions, which I will moderate through the question feature of Zoom's webinar. Thank you, Carol.
Thank you so much, Mark, and thank you everyone, both our co-sponsors and all of our attendees. I wish I could see you. I miss all of you, but I'm really glad that Zoom can bring us together. I have 12 slides today. I'm going to try to keep my presentation to 30 minutes, so we will have time for questions. And the first few slides are primarily for people who may not know about the background of events that led to the enactment of this new national security law. Apologize to those who already know this background, but I think for some people it's important to have an understanding. Hong Kong is a special administrative region of China because of two important instruments: the Sino-British Joint Declaration, which is a binding bilateral treaty registered with the United Nations, and the Hong Kong Basic Law, which is Hong Kong's regional constitutional instrument. And most of the provisions of the Basic Law do come, in fact, from the Sino-British Joint Declaration. Taken together, these documents promise an unusually high degree of regional autonomy. In the theory of autonomy, scholars look at degrees of autonomy, and Hong Kong was initially considered to have an exceptionally high degree. It's because it has its own immigration control, the border is still regulated, it has its own separate customs territory, a separate membership in the World Trade Organization. It has, of course, its own separate common law legal system with an independent judiciary and legal profession. And the local legislature is supposed to have the power to enact laws in almost all areas of law, right? In contrast, the central government's legislative powers are expressly limited to certain areas through Article 18 of the Basic Law. The Hong Kong dollar still circulates, and we have a very high degree of protection for civil liberties, on paper at least. And that is partly because the International Covenant on Civil and Political Rights, which was first applied to Hong Kong by the British government, continues to apply in Hong Kong. China expressly agreed to that in the Sino-British Joint Declaration and in the Basic Law. So even though China has not ratified the treaty, it is enforced in Hong Kong. And it's enforced in Hong Kong in a way that many countries have not agreed to, in the sense that Hong Kong has the ICCPR incorporated right into its domestic constitutional framework through Article 39 of the Basic Law. And that means that the Hong Kong judges will try to interpret legislation so as to comply with the ICCPR. If it's vague and there's two interpretations available, one that would violate the ICCPR and one that would not, the court should adopt that interpretation. The Hong Kong courts have also invalidated local legislation when they could not interpret it to comply with the ICCPR. But notice I said local legislation, and the Hong Kong national security law is a national law. So the Hong Kong courts will not be able to override express provisions in the national security law. Now, in my view, if faithfully implemented, the model of autonomy that was designed in the Sino-British Joint Declaration could provide what I refer to in an article I've cited here as internal self-determination for the people of Hong Kong. And internal self-determination is often a way of reconciling conflicts that develop between territorial claims, and in this case, China did have legitimate territorial claims to regain Hong Kong after the period of colonization. And on the other hand, the normal right of a colonized people to vote on what their future political status will be after decolonization. So it's a compromise, if you will. And it is a compromise that China agreed to in the Joint Declaration, and China got some benefits from that treaty. It obtained a peaceful transfer of sovereignty with an intact economy. So in our second slide, I just very briefly highlight some of the conflicts that have developed over the years leading up to the big conflicts of 2019. The first 5 years were relatively calm. In 2002, the government proposed local national security legislation, and it became very controversial, although in general, I do think the legislation did comply with the ICCPR. The government made some mistakes, I think, in public consultation. It was very reluctant to accept amendments. And as a result, there was a big protest march on July 1st, 2003, and they ultimately withdrew that bill and never tried to legislate locally again for national security, which was probably a mistake. In 2012, we saw the conflicts over the patriotic education proposals, a lot of young people coming out to protest against what they thought was thought control. And those proposals were also withdrawn after entirely peaceful protests. 2013 was a watershed moment. That's when Benny Tai and his colleagues proposed what has become to be known as Occupy Central in Peace and Love. His idea was that if we just occupy the downtown area of Hong Kong, they will finally give us universal suffrage. China had promised the Hong Kong people that they would be able to elect their chief executive by 2017, but they expected it to be done through a process identified in Basic Law Article 45, which describes a, quote, broadly representative nominating committee. Benny Tai and many others were afraid that this would be used to restrict the candidates to something that was not representative. And so the idea was to oppose that. Well, it didn't work out so well, Occupy Central. It was peaceful, but it was very unsuccessful. I think, frankly, it was too controversial and too confrontational from Beijing's point of view. I don't think Benny intended it to be that way. I think he intended it to help the moderates to negotiate something to make the nominating committee more representative. But instead, it had quite the opposite effect. Beijing reacted very strongly. Before Occupy Central started in the spring of 2014, it issued this white paper on Hong Kong, which was very frightening to the people. It really described the autonomy as more like supervision by Beijing. And then on August 31st, the NPC Standing Committee issued a decision that effectively launched Occupy Central. That's what made the students suddenly rush downtown, because they basically said there will be no reforms to the nominating committee. It will be essentially the selection committee that was selecting the CE already. And so it wasn't going to be broadly representative. Following Occupy Central, sorry, I moved ahead a little too fast. Following Occupy Central, I don't know why it doesn't want to go there. We see the rise of localism and Hong Kong. Suddenly we start seeing people really get upset with one country, two systems and feeling that it's not being fulfilled. And we start seeing much more of a harsh reaction from Beijing. Legislators and candidates start getting disqualified for various reasons. The booksellers disappear, one from within Hong Kong's territory. We see far more dissatisfaction with the appointed chief executive. CY Leung, who was the chief executive at that time, was extremely unpopular with the people. So all of this leads up to 2019, where the real crisis starts. By that point, Carrie Lam was the chief executive, and she just messed up big time, no question about it. I don't think an elected chief executive would have been this tone deaf to the people. She proposed a case-by-case extradition bill, which would have allowed for extradition of defendants to jurisdictions where Hong Kong did not have an extradition agreement. She did so because of a case in Taiwan. Frankly, I don't think the Hong Kong people would have minded extraditing a defendant to Taiwan because they have confidence in Taiwan's legal system. The fear was that it could be used as a way to extradite people to mainland China, where there was no extradition agreement. The protests were initially peaceful, but very large. And even the 2 million march in the summer of 2019 did not persuade her to withdraw the bill. I don't know why. She was extremely stubborn and she refused to negotiate. And she apparently just expected the police to solve the crisis for her. And they became increasingly harsh. The police, who generally, when I was living in Hong Kong, were very respectful of protesters, suddenly became far more repressive. Eventually, the protesters also became a lot more aggressive, and the legislature was overrun by some young protesters. They put up British colonial flags, which was very upsetting to the Chinese government. And they became, I think, I don't know how to describe it, but foolhardy, really. Their theory was, you taught us that peaceful marches are useless. And so they felt emboldened, and they really started to damage a lot of things. I mean, when I was in Hong Kong in November 2019, I was shocked by the state of our former campus. It had been damaged so badly. More importantly, perhaps, though, from China's perspectives, you started seeing not only British flags being flown by the protesters, but American flags, including signs saying, "President Trump, please liberate Hong Kong." That was a big mistake. And it actually gave, I think, China an easy excuse for saying that these protests are a threat to national security and somehow organized or influenced by foreign forces. Then we had the district council elections in November 2019. This should have been a happy event because there was such a huge turnout and the pro-democracy parties did so well. But actually, because all the pro-government parties were trounced and Lam could no longer claim that the silent majority supported her, it actually gave the Hong Kong and central governments an incentive to squash democracy even more. So then we see the legislative council elections being postponed by a year, more candidates disqualified, more resignations and protests. And so now the legislature in Hong Kong really doesn't have any pan-Democrats, for the most part, representing the community. So now we fast forward to 2020, and the Chinese government takes pretty much direct control. They start attributing the turmoil in Hong Kong to anti-China forces, and they enact this terrible national security law. It was done very fast. I think it caught a lot of people in Hong Kong by surprise. And it was not even published until the day that it was enacted, and it went into force that night on June 30th. It prohibits secession, subversion, collusion with foreigners, and terrorism. I'm not going to say too much about terrorism, but I am going to talk about the other three categories of offenses. But before I do, I want to point out that really the worst aspects of this new law are the new security institutions. We have a special branch of police with extraordinary new investigation powers. We have a committee for safeguarding national security that makes rules for the police. These decisions are not subject to judicial review. That's explicit in the law. We have a new office for safeguarding national security, which is essentially China's secret police operating for the first time openly in Hong Kong. I'm sure they were there before, but not openly and not with legal powers that they can use. We also have the possibility, which I hope won't happen, but could happen under Article 55 of the central government taking control over a case and taking a person to the mainland for trial, which would essentially be extradition without an extradition hearing. So what everybody was marching against has been accomplished in a very quickly enacted law. Is there any good news now that I've depressed you all? Well, yes, there is. And the good news is that the national security law does say in Article 4 and Article 5 that human rights will continue to be protected. And it specifically provides for the continued application of the International Covenant on Civil and Political Rights, the ICCPR. It also mentions ISCRA, the International Covenant on Economic, Social, and Cultural Rights, which is relevant to some issues such as academic freedom, but it's the ICCPR that is most important. Article 5 also refers to the principle of the rule of law, the right to be presumed innocent, and other important principles. Now, I have to tell you, though, that Article 62 states that if there is a clash between local law and the NSL, then the national security law is going to prevail. But because the national security law is often vague, I think that smart judges should be able to find a way to avoid direct conflicts and interpret vague language to comply with the ICCPR. It certainly will not fix all the problems with the national security law, but I think it might help to modify somewhat the negative effects. And I'll give you a few examples. Jimmy Lai, probably never has a bail application attracted so much international attention, but Jimmy Lai did recently return to jail. He had been granted bail, and then it was successfully appealed by the government. It's an interesting case for me, not only because of the bail application, but also because of what he is charged with. He was partly charged with a fraud complaint, which I'm not going to talk about today, and I don't think is particularly relevant. But he was also charged with requesting a foreign government to impose sanctions or other hostile activities against Hong Kong or China. And this is prohibited in Article 29. Now, I have been told, and I think it's probably right, that this provision was drafted with people like Jimmy Lai in mind, and with other pro-democracy figures in Hong Kong who have gone directly to the US Congress and demanded that the US Congress pass some sanctions to punish China and the Hong Kong government for repressing democracy and civil liberties. In my opinion, that probably wasn't such a good strategy, and I'm not really sure what it accomplished. But it does seem to have generated this specific offense, which was never mentioned in Article 23 of the Basic Law. So some of us were very surprised to find it. And it is a very, very broadly defined offense. And I'll quote from the language a little bit later. Now, the Lai case first became notorious because of his bail application. Although in Hong Kong, there is normally a presumption in favor of bail, the national security law has this really odd provision that says no bail shall be granted unless the judge has sufficient grounds for believing that the criminal suspect or defendant shall not continue to commit acts endangering national security. Well, that word continue sure seems to contradict the presumption of innocence. Are you going to stop beating your wife? It's one of those questions, right? Now, went ahead too far, sorry. Now, when Judge Lee in the High Court was considering Lai's application for bail, he decided to largely avoid looking at that word continue. And he just essentially interpreted the right to bail very similarly to the way it is under pre-existing Hong Kong law. And he applied the normal factors. You look at the seriousness of the charge, the weight of the evidence, the risk of absconding. And in this case, Jimmy Lai was willing to agree to all sorts of very strict conditions. He would be under house arrest. He wouldn't talk to anybody. He wouldn't tweet. He would be almost like Donald Trump, not allowed to express many opinions on social media. And he was willing to agree to that. And the judge did grant bail, albeit with these strict conditions. Interestingly, the judge also noted that the evidence relied upon the prosecution didn't seem to be that strong. He mentioned that the statements that Lai had allegedly made appeared to be more like comments and criticisms rather than requests for sanctions, which is an interesting comment and something to think about when his trial eventually comes around. Now, the government appealed the granting of bail, and the case made its way to the Court of Final Appeal, which is the highest court in Hong Kong and a very well-respected court. The court set aside the granting of bail, and it held that the judge had misunderstood Article 42 of the National Security Law. The court said, this article does create a more stringent threshold for bail, and you can't ignore it. It's more of a presumption against bail, although they avoid using that word presumption. Now, the Court of Final Appeal added some other important words, though, and it expressly stated that the national security law in Articles 4 and 5 stipulate that freedom of expression and other human rights will continue. And the court said this provides the context in which Article 42 must be construed and applied. As far as possible, this bail provision is to be given a meaning and effect compatible with those rights, freedoms, and values. And I think that applies to everything else in the national security law as well, because Articles 4 and 5 apply to the entire national security law. So in other words, if there's an explicit contradiction, then unfortunately the courts will have to enforce the national security law. But if you can interpret vague language to comply with the ICCPR, the court should do so. And the way the court did it here was simply to say, well, the word continue must obviously not be read as implying that the accused is somehow to be treated guilty, right? Because that would fly in the face of NSL 5's adherence to the presumption of innocence. So I think these general principles are positive, and I think that they could affect future trials. So if you look at another offense, newly created offense in this law, in Article 22, the offense of subversion, I think you can see what I mean. Article 22, I've quoted the key language, some of the key language for you in the middle of the screen. It says that it's supposed to be confined to people who organize, plan, commit, or participate in any of the following acts by force or threat of force or other unlawful means, with a view to various goals: subverting state power, overthrowing the basic system of the PRC, overthrowing the power of the Hong Kong SAR, et cetera, et cetera. It's broad, but it does have those words: by force or threat of force or other unlawful means. Now, in my opinion, an ICCPR compliant interpretation of Article 22 would not include participating in a political primary. But that's exactly what the police seem to be doing, because in January of this year, 53 people were arrested for subversion. And the statement that the government and police gave is, well, they participated in the Pan-Democrats candidates' unofficial primary. Now, they haven't been charged yet. They've all been released on bail. I wonder if they will ever be charged, because I sure would not want to be the prosecutor who tried to stand up in front of a court and say that participating in a primary is unlawful means. I mean, the UN Human Rights Committee, which is the treaty monitoring body for the ICCPR, has always said that you cannot use national security as a pretense for suppressing multi-party democracy. So it makes me wonder what the government is up to. The government claimed that the Pan-Democrats were trying to paralyze government by gaining too many seats. But that's what competitive democracy is about. You try to gain more seats and you try to increase your negotiating power with the executive branch. That's what Mitch McConnell will be trying to do if he can try to regain the Senate, right, in the next Senate elections. I don't think the Hong Kong courts would accept that as fulfilling the requirements of Article 22. I don't know, but it's hard for me to imagine that they would do so. And so it may be that these arrests are just designed to harass people, to intimidate people, and then perhaps the cases will just be quietly dropped. I honestly don't know. Articles 22, 20, and 21 govern secession. Sorry, I'm a little trigger happy, I guess, on my mouse. Secession is defined in Article 20 as a person who organizes, plans, commits, or participates in any of the following acts. Here it says whether or not by force or threat of force, with a view to committing secession or undermining national unification. They're talking about acts that would separate the Hong Kong SAR from the People's Republic of China, or separating some other part of the People's Republic of China, such as Tibet, right? Now, the provision that I think is most important and the biggest threat to speech acts is Article 21, which is what we call the incohate offenses: a person who incites, assists, abets, or provides pecuniary or other financial assistance or property for the commission of other persons of the offense under Article 20. Now, what's worrying about this from the police behavior's point of view is that the police appear to be interpreting Article 21 as including the mere display or even the possession of materials with slogans that were suddenly deemed secessionist by the Hong Kong government on July 1st. If you look at the report that I've cited there, that's just come out recently from Georgetown Center for Asian Law, you'll see a very helpful appendix. It lists all 105 arrests as of a couple of weeks ago. 53 of those 105 were arrested simply for participating in that primary, which is shocking. But the next biggest category are people who have been arrested for inciting secession. And then when you look at the background, you'll see their backpack was searched and we found a sticker on their phone that said "Liberate Hong Kong." So that's a pretty broad interpretation of incitement, in my opinion. And I think that such a broad interpretation would likely violate the ICCPR. Now, fortunately, almost all of these arrestees were released on bail. The ones who are not were accused of something else, such as the man who drove a motorcycle into the police while waving a flag that said "Liberate Hong Kong." So these people are on bail, that's good, but I wonder what will happen if they're prosecuted. Because it could lead to a real conflict between the local courts in Beijing. I can foresee a situation where the local courts are not going to want to interpret that as incitement, just having something in your backpack that says "Liberate Hong Kong." But if those people are not convicted, it's possible that that could lead to a conflict between the local courts in Beijing. And unfortunately, the NPC Standing Committee does have the overriding power to issue a legislative interpretation of the national security law if it wants to. So we're going to have to watch these cases very carefully. In the meantime, of course, it takes a very long time for any cases to work their way through the courts in Hong Kong. So these people are living under the fear of prosecution. All right, so now I have just 2 slides left, and I think I will just about keep within my 30 minutes of predicted time. And I want to talk a little bit about what the international community can do. In the abstract for my talk, I mentioned it's too soon to write off Hong Kong as being just another city in China. And I do feel very strongly about that. I feel that some of the commentators are doing that. And it makes me sad because there's a big difference between Hong Kong and other cities in China. Hong Kong does still have an independent judiciary. It does still have a largely free media. I mean, you can read very critical articles and listen to critical discussion on RTHK, the public radio station. It's not what it used to be, I admit that, but there's a huge difference between civil liberties in Hong Kong and civil liberties in China. We may be going in that direction, but I don't think we should write off Hong Kong yet. We have to think about how the international community might help to preserve civil liberties in Hong Kong. And the UN bodies that monitor human rights are trying. In June, when this law had been announced but had not been published yet, the UN High Commissioner for Human Rights issued a public statement reminding Beijing that any law in Hong Kong must comply with the ICCPR. Beijing reacted very strongly. It said these remarks grossly interfere in China's sovereignty and internal affairs and violate the purposes and principles of the Charter of the UN. Standard Beijing language. Then in September, there was a letter from 7 independent UN human rights experts, and they issued a letter with a very detailed analysis of the national security law, critiquing it. And Beijing said they had grossly interfered with China's internal affairs, seriously violating the mandate and code of conduct of the special procedures of the UN Human Rights Council. In other words, Beijing is not just disagreeing with this commentary, it's trying to attack their right to comment. And that is why I hope the United States is going to get involved again in the UN Human Rights Council, because it's important that we counter this thinking that the UN Human Rights Council and its special mechanisms do not have the right to comment on domestic human rights situations. That's why they were created. That's their purpose. And China voluntarily agreed that the ICCPR would continue to apply in Hong Kong. It wasn't forced to do that. It offered that, and it got something in exchange. So I think it's important that we support these processes as much as possible. multilateral human rights processes are an excellent way, in my view, of supporting the Hong Kong people without necessarily adopting punitive sanctions that could actually hurt the Hong Kong people. Now, the Human Rights Committee is scheduled to review Hong Kong's pending report. It hasn't adopted a formal date yet for the hearing, but the report is filed. The list of issues has been sent to the government, and the Human Rights Committee has requested extensive information on the national security law for its upcoming review. The question I have is whether NGOs will also participate in that review. Hong Kong NGOs have traditionally participated and provided information. I think a lot of them might be intimidated now, which would be a real shame. If so, international NGOs can provide that information. Now, my final slide, what about foreign governments? That's always trickier, partly because we are at a very difficult time in the American-Chinese relationship. The Trump trade war made things worse, in my opinion. And I think poor Hong Kong has suffered. I think that's one of the reasons Beijing felt the need to come down so harshly on Hong Kong. And so what can foreign governments do to hold Beijing accountable, but avoid unintended negative consequences for the people? The UK, the British government, clearly has a right and indeed an obligation to monitor implementation of the Joint Declaration. The treaty is still valid. They have a right to question breaches. They have indeed opened a path for British national overseas, the BNO passport holders, to move to the UK. It's upset Beijing, but it's legitimate. It's a legitimate response to Beijing's many breaches of the Joint Declaration. Other governments also have a right to monitor civil liberties in Hong Kong. And this is why it's not just an internal matter. Extradition agreements, for example. Because of Hong Kong's distinct legal system, many countries that did not have extradition agreements with mainland China were willing to extradite people for trial to Hong Kong because they trusted the legal system. A lot of them have suspended their agreements now because they're nervous about this new legal regime. They've got to consider, are they going to continue to suspend their agreements? Will they have confidence in Hong Kong again? They need to know. Frankly, foreign governments also need to advise their citizens who live in or travel to Hong Kong because there is extraterritorial reach of this law, which is exceptionally robust, and there's no double criminality requirement. And what that means is that a person who might, say, lobby for sanctions against Beijing and Washington may assume that they're safe because that's not a crime in the United States or in any civilized country, but actually it is a crime under the NSL, and under the extraterritorial provisions, you could be charged if you were to travel to Hong Kong later. So that's something that governments have to keep track of, and they have to advise their citizens. That being said, I do think that some of the punitive sanctions that the Trump administration adopted went too far and actually hurt China, hurt Hong Kong. For example, the Trump administration announced that goods that come in from Hong Kong must be labeled made in China. I found that kind of heartbreaking because frankly, as a consumer, I like to know if my goods are coming from Hong Kong rather than mainland China, but also what does it do? How does it help the people of Hong Kong to maintain their autonomy? If anything, I think it might actually advance Hong Kong's economic integration with the mainland, which might hurt its autonomy. So in conclusion, I would say we have to acknowledge there are certain red lines now that you can't cross if you don't want to be arrested in Hong Kong. If you've got one of those Liberate Hong Kong, banners rolled up in your backpack, make sure you take it out before you land in the airport in Hong Kong. Make sure any stickers on your phone don't say anything like that as well. But still, I would say that Hong Kong is still very different from mainland China because of all the factors that I've listed here. And it would be a shame if we were to inadvertently hurt Hong Kong's autonomy, but giving up too soon on the hope that the Joint Declaration will be enforced. And thank you very much. That concludes my remarks, and I'm very happy to hear from our commentators or if we have any questions afterward. Thank you.
This was a fabulous talk, Carol.
Well, thank you.
I'm very glad that you produced this elaborate outline summary of your talk, which I think is invaluable. And I hope you could make it available right away to all of us who've been your auditors, because Your admirable talk in 40 minutes is too much for the human mind, even those of us who are informed about Hong Kong, adequately to assimilate. But having said that, and giving you full credit for a remarkable talk, and I agree with it, you'll hear one or two qualifications. But first of all, I think you're a little too modest. And second, I would think that you're too optimistic about the ability of the Hong Kong courts to arrive at the preferred restrictive interpretations of the national security law. We don't have to look any further than the consequences of the Court of Final Appeal decision with respect to Jimmy Lai's bail. When I read that, I thought, Jimmy Lai can be granted bail. He can meet all the presumptions because, as you say, he had inflicted on himself, in order to get out of jail, a huge number of restrictions that would keep him at home innocuously under house arrest. And yet he didn't get bail. And he didn't get bail immediately. And the opinion of the court is not persuasive. And what we've seen is an immediate restrictive application of what might have been, as you pointed out, a fairly optimistic interpretation by the Court of Final Appeal. So we have that immediate result. The next day, in a case, as you know, that doesn't involve the national security law, a judge taking account of the previous day's Court of Final Appeal decision immediately extended it to apply to a local offense of sedition. And I don't know whether that's going to be appealed and whether it will get an adequate hearing. I've got many points to make, but let me just run through a couple quickly. One is the January 6th arrests look to me, as you say, not to be serious accusations in most cases that'll be prosecuted, but I think they lay the basis for disqualifying people from future participation in the political process. And of course, I think that's outrageous. Secondly, when you look at the assurances China gave that the ICCPR would be applied, et cetera, that wasn't done under the administration of Xi Jinping. We're dealing with a very different ballgame now. And I think, as you imply, we're likely to see a serious clash ongoing at every level of UN organization to which we can look for assistance. I think maybe the broadest point to take into account is the courts are not static. The courts of today are not the courts of a year ago or 2 years ago. We've seen a number of attempts that have succeeded in hemming them in, starting with the restrictions imposed on who can try national security law cases. Why do there have to be special judges approved and other judges not approved? And how are judges assigned? A different judge considered the second Jimmy Lai appeal the other day for bail to the High Court than the sympathetic one who had made the first decision that was criticized by the Court of Final Appeal. How is that done? How are judges assigned now? And was there a secret meeting between Chief Executive Carrie Lam and the Chief Justice? I saw a report on that. No one seems to have followed it up. There are a lot of things going on. And it's not only the bar, the court that's under attack, the bar, the litigating barristers who are essential to any human rights protecting system in Hong Kong are now under attack, as you know. And the new leader of the bar is under enormous pressure to resign because he had the effrontery to suggest that maybe some amendments could improve the human rights under the national security law. So finally, what can we do about it? I think the United States, in addition to the various measures you've mentioned, at the United States and other liberal democracies can open their doors further to welcome anyone from Hong Kong who wants to leave, and not only open in principle, but make available the financial support that many of these people will need to get set up in the United States, and will need some support for the future. We can do that. That's not harmful to the people of Hong Kong the way sanctions are. And the whole sanctions thing, I think, are a little silly because we know who's responsible. Xi Jinping is where the buck stops in China. And under the Magnitsky global sanctions, he's the one who should be held responsible. But we can't do that in practice and hope for any solution at all. So I like the unilateral measures by each liberal country to welcome people from Hong Kong and do it quickly and do it with financial support. But again, this is a fabulous talk, and I hope you'll send me immediately a copy of your great outline.
I can now unmute, and I was going to introduce Professor Cohen before, but let me suggest this. Carol, if you want to make any quick response to Professor Cohen, you go ahead. Then I'll reverse, just share with the audience Professor Cohen's introduction, and we've got a few questions. We won't have much time, but we'll try to pass on the questions to Professor Peterson that we're not able to answer. So others with questions, please feel free to put them into that system with the webinar. Carol?
So thank you so much, Jerry, for those comments. You're right, I'm probably too optimistic. People always say that I'm an inherently too optimistic person. I totally agree with you that all liberal countries should open their doors to Hong Kong people who want to leave. The difficulty is, though, I think, we can see you now, Jerry. The difficulty, I think, is that, you know, a whole lot of people don't want to leave. Hong Kong is their home, and it's really sad. And so that's why, even though I agree we should welcome those people who want to leave, I still think that we have to do our best to preserve what maybe can be preserved in Hong Kong, even though I recognize it's not going to be the same Hong Kong that you and I lived in, right? It is going to be different. Your comments about the Jimmy Lai case, it's interesting. I was also shocked when Jimmy Lai was ultimately denied bail, because when I read the Court of Final Appeals decision, I thought, okay, they've opened a path where the judge below now can apply what they say is the correct standard, and then look at these onerous conditions he's willing to agree to and grant bail. I found out just last night listening to a webinar in the wee hours of the morning from Hong Kong, where somebody was discussing the Lai case, and someone who I think had some more information than I do about the case said that he heard that the prosecutors put in more evidence at the subsequent bail hearing. And so that maybe that may have complicated it, that it wasn't just like a repeat of the bail application, but with a slightly new standard. So I think I'd like to find out more about that. The sedition offense that you mentioned, right? So sedition, for those of you who don't know, is prohibited under the old British colonial ordinances that are still there in Hong Kong. And one of the things that we had hoped would happen when the National Security Bill was proposed in 2002 and 2003 is that sedition offense was going to be reformed so as to comply with the ICCPR, because everyone agreed that it didn't. And it wasn't being prosecuted anymore because of that. So now it is being prosecuted, and you're right, the government is arguing you should apply the same strict bail standards because it relates to national security. The courts seem to be doing that. But the one comforting thing to remember is that because the definition of sedition is in a local ordinance, the local courts can not only do their best to interpret it to comply with the ICCPR, but can actually strike down provisions that don't comply with the ICCPR. So in one sense, the sedition prosecution might actually offer an opportunity for improving at least that part of the legal framework. I realize that's sort of a small comfort, but it's something that I'm watching. I fully agree with you that the real aim behind the January 6th arrest is probably to provide a basis for disqualifying people from running for office. And I completely agree with you that it all, comes back to Xi Jinping, and he does. He has no hesitation about interpreting the joint declaration much, much differently than the people were told by Deng Xiaoping that they could interpret it. The interesting thing, I think, with respect to the democracy movement, two things. One, I think all of these disqualifications and the postponed elections make the DAB, the pro-Beijing political party, and some of the other pro-Beijing political parties look really foolish and really pathetic. And I did listen to a webinar recently where a prominent member of the DAB said, we really do want to find a way to be more responsive to the people and actually win elections. They were winning elections for a while. When Carrie Lam became so unpopular, they did miserably in the district council elections. And I'm just hoping that maybe there will be some desire among these local pro-Beijing politicians to kind of restore their dignity, because it makes them look really foolish when the only way they can win is if everybody else is disqualified or arrested. And then finally, there was one comment, then I'll turn it over to Mark, that I did see in the Q&A before I closed it so I could speak. Someone said, would you agree at least that the Trump administration was supportive of the pro-democracy movement? And I don't agree with that. I think the Trump administration was actually using Hong Kong's democracy movement for his own advantages to get some leverage over Xi Jinping. And it made me very sad when I was in Hong Kong when the students had taken over Hong Kong News campus, and I was walking around talking to them because all the classes I was supposed to go to were canceled. And I talked to a lot of students about this, and some of the students could see through that. They said, we would never wave a Trump flag. We realized that he's using us, but some students didn't realize that. They somehow really thought that Donald Trump was going to come in and rescue them. And I found that really awful and disingenuous, because I think it might have actually encouraged students to do some things that were quite reckless and not in the long run good for them or good for the democracy movement. But that's the way politics works sometimes. But thank you very much for your comments, and I will certainly make my slides available to anyone who wants them.
And I should mention that this entire talk we plan to make available as a online recording, so the slides will be there. As I said, I wanted to very briefly introduce Professor Cohen. We're delighted he's here. We had some connectivity problems, so I didn't mention him at the start, only because I wasn't sure we were going to get him. So I'm also thrilled that that worked. So Professor Cohen is the Faculty Director Emeritus of the U.S. Asia Law Institute at New York University. And as I said, we're really thrilled to have him here with us today, and had asked him if he would share a couple comments in response. We've gotten a bunch of questions, and I don't think we'll have time to get to all of them. So I'm going to take the liberty of selecting two that go to what we can do. So sort of the audience perspective. And I'll give you them both, Carol, and then give you leeway to go. One is maybe bigger, one is smaller. So Elizabeth Donkervert generously shared that you've mentioned the independent judiciary as a difference between Hong Kong and the PRC, but you were concerned that the judiciary could clash with certain circumstances if it were to favor the ICCPR. So what can the international community do to support the independence of Hong Kong's judges? The second question is pragmatic for you, for me, for many of us, and that is, has travel to Hong Kong changed for Americans? And I might suggest a separation between Americans like yourself and many of the people in this audience who are already engaged with Hong Kong, and then separately, how people should think about it if they are not yet engaged with Hong Kong or only peripherally.
All right, thank you very much for those questions. For Elizabeth's question, I think we can support the independent judiciary in the same way we can support civil society generally, and that is, I know the international human rights monitoring process sounds weak often, but really what it boils down to is name and shame. And although Xi Jinping maybe doesn't have a lot of shame, I think he has some. And I do think that just focusing attention on it. And of course, there are international judicial organizations that can help support Hong Kong judiciary. And I don't think they'll just favor the ICCPR. I really do believe that the courts will do their best to enforce the ICCPR in Hong Kong. Although I totally accept what Jerry said, that they are under a great deal of pressure and there may be encroachments on their independence soon. Has travel changed? Well, travel's changed for everyone right now because of COVID, and we can't go. If you want to go to Hong Kong, you're going to be in a quarantine hotel for a few weeks and not be able to leave your room. They're very strict. They also have far fewer cases than we have had. So they may have done a better job than the United States in restricting transmission of COVID. But in the long run, I think travel will be very much the same, except I do think you need to educate yourself about those bright red lines. If you are just going to Hong Kong to enjoy the shopping and the really good food and hike to the peak, that's probably not an issue. But if you have been involved in any way with civil society, you do have to be a little bit mindful of certain red lines, like those slogans, Liberate Hong Kong, Glory to Hong Kong. Those are basic speech acts that should not be unlawful in an ICCPR compliant jurisdiction. But if there's a clear contradiction between the national security law and Hong Kong domestic law, the national security law will be enforced. Moreover, you don't want to get arrested, even if in the end the courts would say that you were actually not violating the ICCPR because the courts give a more ICCPR compliant interpretation than the police did. So I'm very careful not to cross red lines. And let's face it, there are a lot of countries that you go to, you have to be careful about what you say for a variety of reasons. You can't insult the monarch in some countries, right? You have to be mindful of certain red lines. I do feel very strongly that you can still participate, say as an academic, if you visit a university in Hong Kong, in critical discussions. And there are Zoom events that you can sign up for. If you go online, if you're interested, if you're a lawyer, look online on Chinese University, City University, or the University of Hong Kong. They all have law schools. They are all putting on online Zoom events, and they are still offering critical commentary. So academic freedom is still being practiced in Hong Kong. And if you want to travel and engage in those events, I think you can still do so. Just be mindful of the red lines and the extraterritorial application.
Well, this is exciting because we still have more time. So let me go.
Jerry might want to add something to that.
Jerry? Sure.
Yes, I think you should also stress our activities before going back to Hong Kong. What we're doing here. Whom are we cooperating with? Last year, I put on a program at the Council on Foreign Relations. I had two guests. One was Martin Lee and the other was Jimmy Lai. Now, I can't do that now. I've invited several important authorities on law and government from Hong Kong to participate in current programs, and they're all being very discreet. And they know if they cooperate with me, I certainly can be subject to prosecution if I'm unwise enough to pass through Hong Kong. To his credit, last night we had a great program with Associate Dean Simon Young of the law school, who's a leading expert on criminal justice in Hong Kong. And he did a remarkably objective job. I don't think there'd be any basis for trying to prosecute him or those of us who cooperated with him from here on the program. But you never know. You can talk about red lines and be careful of them, but we have no clear red lines now. We don't know what colluding with external or foreign forces means. So far, I think it's high risk for people in Hong Kong. It may be very low risk, especially for people who are ancient like me. I hope that Martin Lee will not go to prison, that people will say he's 82 years old and the court will agree. Chinese law on the mainland has always tried to be more generous to convicted people who are old in age. But there are no clear red lines now under the national security law, as you've indicated, Carol, in a couple of respects, and certainly with respect to foreign collusion.
Okay, well, so that actually does bring us closer to 1 o'clock. And so those of you who've shared questions, we'll pass them along. I also just want to thank Professor Cohen again for coming, and for the audience to know that we can continue to get Professor Cohen's insights. He maintains a blog, which one can receive regular updates on via email, as well as the activities of the U.S. Asia Law Institute, where I believe Professor Peterson is now a co-editor of one of the journals. And then we've got 32 attendees. The number was a little higher. I guess some people had to go off to teach, but I want to thank everybody for attending. This has just been absolutely terrific. And more than anything else, I want to thank my colleague, Professor Peterson. What an honor it is for me to be here, able to listen and learn from her. I listen and learn from her often. Miss being on a corridor where that can happen more casually. But I do feel really privileged to be able to work with the Peterson, and I'll give a shout out for her husband in another room, the Peterson and Booth pair that came to our school some years ago.
Well,
so with that, go ahead, Carol.
Just thank you very much for organizing the talk. I appreciate it. And thank you so much to Jerry. I hope we'll all see each other in New York, Honolulu, or Hong Kong someday soon. And thank you to the participants for being so interested in Hong Kong. Keep your eye on it.